Hey guys. Hello, 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 hello. Hey, 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 hey. Y'all want to see what I look like now? Do you guys want to see what I look like now? Hey, Denise, you want to see what I look like now? Denise, you want to see what I look like? Because earlier I was looking like buckwheat. You want to see what I look like? She finished. Y'all ready to see what I look like? You ready? You ready? You ready? Okay, hold on, hold on, hold on. Ready? Y'all ready to see what I look like? Ready? Bam! 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 No more buckwheat. Bam! No more buckwheat. No more buckwheat. No more buckwheat. No more. See? Got some hair. See? No more buckwheat. No more buckwheat. No more Coolio. See? Remember? Okay, see? All that Coolio stuff that was going on. No Coolio, no what was the other name we had? Edward Scissorhand. None of that. No more of that. She didn't do my makeup. Next time I guess I'll get her to do my makeup. She didn't do any makeup. So see? See? Mm-hmm. Mm-hmm. No more Hellraiser. No. Hey, stay safe. See? Okay. You was messing with me earlier. Okay, hold on. Let me. All right, come on in, guys. My readers, come on in. Yeah, she did that thing, y'all. See, she wrapped her hair around it. See? Remember the buckwheat stuff that y'all saw? She wrapped the hair around it. Oh, gotta put it back, y'all. Gotta put it back. Yep. Mm-hmm. How long it keep it? She said it'll stay for about a month. She said about a month. It depends on if I tie it down at night. But she'll do like if it unravel, she'll put it back. She'll do it again. See, I don't like hair, so I just told her do something short. So. She could have did it smaller, but I ain't know that small stuff. That means it's gonna hurt. That stuff hurt because she got to put the little crochet thing in, and then she twists the hair around it and all that. So, thank you, Samantha. Mm-hmm. Thank you. See, they were saying, "Oh, I look kind of." Do I look younger now? Do I look like about 50? I'm looking younger now, right? Mm-hmm. Yeah, I'm gonna put the bonnet on it tonight. But it's gonna be hard because it's tight and it hurts. Because she wrapped the hair around my hair, and it hurts. Yeah, butterfly crochet. Yeah, that's what they call butterfly crochet braids. Yeah, that's what they are. Yeah, it hurts. Hey, Henny Hen. Guys, I'm putting a link in there. I'm putting the link so you guys can come on in so we can start the reading. I'll start the reading. Hold on a second. See if I got my little. Look like a different person, right? I look like a different person, don't I? Mm-hmm. Okay, let me take the brand off. Hold on, let me take the banner off so you guys can see me. Okay, take the banner off. See? Don't I look different? Mm-hmm. Hey guys.
Boom shakalaka.
Hello, everybody.
I look about 20 years younger, don't I, y'all?
All
You
right
look
there.
beautiful.
Hmm.
You look beautiful.
Oh, thank you, darling. Thank
Okay.
you.
Hey, Gaddis.
Yeah,
Hi, Granny.
I was waiting for my watermark. Hold on a second, see if she got it done for me. Because
Okay. We're reading from the one yesterday, right?
No,
Continuing.
we finished the one yesterday.
We did? I thought I
Mhm.
was in the middle of
He wasn't there.
still had
No,
a
you
little
talk.
pause.
Oh no. You talking about no. We're talking about we're doing the pretrial. We were doing those pretrial
Oh,
interviews.
with Cardi B and them or something?
No,
No?
pretrial for Robert. Pretrial.
Did you send me that?
Not yet. I'm waiting
Oh,
for
okay.
my work.
Okay.
I gotta
Okay,
wait.
gotcha.
This is the one that I gotta go get my phone because Gloria says she's gonna come in and answer questions for us. If there's any
Okay.
questions. Hit the thumbs up, y'all. We got only 30 people. Is somebody live today? Because we're not getting the numbers right now.
No, I ain't been getting
Come on, let's
notifications.
get the numbers up. We got 32 in here. Let's get those numbers up. 32 in and only 11 likes.
Yeah.
So we're not doing the transcript.
Yeah, we're doing the transcript, but Gloria's gonna come and answer question if we need any questions answered.
Oh, okay.
Thank you, Shay. I look like a different person, y'all. I left out of here looking like one person, and I come back looking like somebody else.
So we're on 301, right?
Yeah, but we're not reading that one. We're reading the what I'm getting ready to send you. Hold on a second.
Oh.
Hey, Tennille. Hey, Susan. Hey, guys.
Hey, Elizabeth.
Wait a minute.
Hi. Why am I
You know
getting
what?
a
Let's
delay?
just because we don't have anybody else to read the other one, so we gotta wait. Gotta wait because I was waiting for unique thoughts. She said she was gonna come in and read, and Candy Cane is sleeping. It's late for her over there. Mitzvah. I don't know where Mitzvah is at.
Hello, staying safe. She's safe. Why am I getting a delay? I can hear it in my ear.
I don't know. I can never get people to come on. There she go. Unique thought. Come on. Come on, young lady. Let's see. Oh no.
Let me come back into
Okay.
your stream because I don't like this.
Okay. He said, "Tell Canada to keep talking." They hear.
Testing. Hello.
uh, 71
Can you hear me?
suburban girl. Yeah, I can hear you. 71.
Well, that's crazy because I don't even have a stream up. Yeah,
Mm-hmm,
I see something is up. You can hear me.
mm-hmm.
I'm talking, but the stream isn't even up.
They've been acting up all day today.
Yeah. It's crazy. Okay, let me wait. I'm gonna come out. Let me see. Let me end it because if I try to come in again so I can see, then it's gonna be that double. Hold on.
Hey, Canic. See that 31? Thank you, woman of God. I'm trying to wait for this thing to come through. Else we're just gonna have to read the old one. Is he in? Let's see. No, he's not here yet. Just a second, guys.
Okay, I mean, can you hear me?
Mm-hmm.
Okay. Yeah, it was getting. I don't know. I think it was. Let me go double check on the live. If I click
Mm-hmm.
the play, oh no, I still hear myself. Okay, I'm just leave it alone because
I
I
hear.
can still hear.
You have to
Oh,
turn it down. You have to turn it down.
turn what down? I don't have anything up.
You don't have nothing up.
No.
That's Unique Thought. She's playing YouTube. Unique, turn it down.
Hello, hello, hello.
We hear you.
Okay, that's good. I don't hear no feedback. That's good.
Miss Getty, see, you're not in. Your thing saying device not connected. We always have
Who's
some
that?
sort of issues with this stuff here.
Shout out to the chat room. Hello, people. How was your Monday? How was your Monday today? Okay, I see 33 likes and I see 63 people in here. So
Look,
we're like,
Rena says, hey, pretty lady Sylvia. Sylvia's back. Infamous is back. Bye, Coolio. How was Coolio earlier?
oh,
Oh, y'all wrong.
y'all leave Spike Lee alone. Come on.
Hold on a second. I'll be right back. Hold on. Talk to the people,
Okay.
y'all, while I come back.
64 people, 34, and one down. So we got a hater in the room, huh? I guess you want to be called out because you gave that thumbs down. I see you, hater. We got some haters in here watching. We just want to acknowledge you. You're in the bushes hiding. You're not going to say anything, but we can tell 64 people and 34, 72 people, and 34 likes. So please hit that like button as you come in or before you come in. Hit the like button for us. Show your appreciation. 38. That's what I'm saying. It's going up. It's going up. Hit that like button, please. Appreciate you all. So how was everybody's Monday? Did you go crazy because you wasn't able to get on Facebook or Instagram? I know I didn't because I don't allow that to rule me. So it was cool, you know. Some people probably lost their mind because they wasn't able to communicate, but you don't worry about that. You didn't let it affect you. Staying safe, no, didn't affect you. That's right. Swerving girl, baby, they hear that voice, and them numbers are moving. Thank you, thank you, thank you so much. Thank you so much.
He be
Can
so
you all hear
with
me?
that voice, man. He just be doing
Thank you
it with
so
that.
much.
He be
She
like, thank you
said
so much.
the
Thank you so
numbers are jumping
much.
up. They are jumping up. We got 2 haters in here though. It's all good. Like to shout you out, the thumb down haters. It's all good. Now, why do we get a thumb down and we haven't started reading? We haven't started doing anything,
Cause
and
they
you
hate
just
it.
come in and give a thumbs down. Are you hating that bad?
Haters.
It must be something because you keep coming back to this page to give a thumbs down. So obviously, we must be doing something. We must be doing something right because you keep coming back hating. Hmm. Hmm. Folks lost their minds. That was the best up in here to stay. It was. It was the best. Let me tell you,
What was
it
the
almost seems like life was normal again with no Facebook and no Instagram.
use your
I'm
card?
not even on WhatsApp, so I didn't even care. I didn't even care about the other ones. It lets you know that there's life after that. Everybody had to come over to the YouTube pages. You have to come to YouTube. Yeah, that's right. It's going to become the dominant page right there. Because I eventually think they're going to, I'm sorry, eventually, I think they're eventually going to break up YouTube. I mean, I'm sorry, not YouTube, Facebook. Facebook, because they are, that Mark, well, that guy, you know who it is monopolizing the social media and stuff and trying to control and have it. So I'm glad it crashed. I'm so glad it crashed. Okay, let me see. Let me read some of your messages. Let's see here. I didn't. I got a life, Gucci. That's right. Never knew about it. Staying safe, okay? I didn't know either until the news was saying, that. Well, it was funny because there was a whistleblower that came out and kind of, let them know what they were doing over there and what he was doing, and that was interesting. And all of a sudden, it crashed. So I think uh, that probably was done purposely by you know who. Uh, MZ is his initials, and I think that it was done on purpose because they probably was trying to dump a lot of stuff or whatever it was that they were having in there. They were trying to dump it, so they did that. I think to do that, getting rid of some stuff. So Denise said, "Nope, I read the Bible." Amen, sister. Nothing wrong with that. Nothing at all. Gucci woman of God that Susan Donna here. I know Mr. Canny can sing with his voice. Uh, one day I'll get I'll have some spirits or something. You know what I mean, and get my courage up. Get me some courage up to kind of do something then, but just trying to do it just off the cuff. Tell them what it sound like. I don't want you to stop listening to me, especially if I hit the wrong notes. Da-da-da-da-da. Angela, thank you. Thank you. Elizabeth Cannon, you have a fan in the chat at Stanson. I'm gaining a few fans on here, which is really nice. Sylvia's made me a co-host. That's my girl, so we're gonna try to do something really good with her page, make have some real good content, do some nice, giveaways at times. So we're gonna spruce it up. Probably gonna see whether or not if
Okay, we're waiting. We're waiting on to read the transcript. That's what we're about to do. Read the transcript on because she's asking what's the topic. We're getting ready to read the transcript for August 3rd. This is the pretrial. There's some. It was the second part of the Curcio. I know we read yesterday that one, so now we're gonna go ahead and read the one.
did you send it to me yet? No.
Huh?
Did you send it to me yet?
No.
Oh, okay. I'll just checking. Rena Jones, we got Barry White on this panel. I was like, hold on a minute. I'm about to play. Practice what you preach.
Uh-oh. Sing it, sing it, sing it, sing it. All right, y'all.
Okay.
1 second. I'm trying to get the person that does it for me. Hold on.
Ready Red, what happened on Facebook and IG? It crashed. It crashed worldwide. Can you can you believe that? Yeah, it crashed worldwide. Interesting, right? Yeah, that was real interesting. Yeah, they crashed big time. So something was up, something went down, and then the whole page, everything went. So isn't it the truth, Kimberly? Yeah, Kimberly reminds me when life was simple, and it still can be. Just don't allow it to dominate your days. You know what I mean? Because I will admit, when it first came out, you were like addicted. You know what I mean? It was like a drug. It was actually going into work and couldn't really do your work. How many did that affect when it first came out? You know, and you had these devices, these smartphones, and you were getting backed up in your work and different things like that because you just kept checking that Facebook page. It was like a drug. You just had to see who was on, who said what, who did this. You know what I mean? Probably broke up a lot of relationships too because they went on to see who made comments on that and were being questioned, who is that? And why is she commenting on your picture? You know, it was just destroying a lot of stuff.
Okay,
I
you
think
can go ahead
Facebook
and
did
check
that.
your email.
No, it'll let me know when it comes. Okay, there you go. Oh yeah, they'll let me know when
You
it
need to
comes.
go check your email.
Mhm. They're restricting a lot of things people use to abuse people in their life. That is all true. Lady Earth, hello, hello. Lady D, hello. Denise, hello. Lady Coltrane, hello. Gucci, Gucci, Gucci. Lady
Moses,
Coltrane,
there you go. There you go. Lordship is in trouble. He's in another form, y'all. His lordship is too much.
Susan Donahue, that voice makes me forget all my troubles.
Your
Oh my
voice,
God.
ooh.
Makes them
Let
forget
me
all.
drink some water to
If
that.
you having any troubles, that's all right. You can listen to me anytime. I'm right here with Sylvia, so trust me. When the page get up and get going right there. But right now, I'm gonna ride
Let
Sylvia.
me drink to that.
Get her, get her up here to about 25,000. I'll put it that way. I'll put the pressure on me. When
All right,
Sylvia reaches
where's Miss
25,000
Geddes?
subscribers,
Where'd she
I will
go?
create my own page. How about that? Get her to 25,000 subscribers, and then I will create my own page, and then you can follow me. But my page would basically be like a DJ, you know, with your music, your favorite old school songs and different things, and chatting in between like that.
A child
Hmm.
says she loves your voice.
Who said that?
Ooh, child.
R. Kelly innocent, glad it crashed. Facebook deserved to go down for good. You right. Everybody feel that way. Stand safe at Terry. My Monday was a blessing because God gave us another day. My mother went to her doctor for physical, and she is great at 75 years young. That's right. God is good, right?
Yes,
How
he
was your
is.
Monday? Terry said, my Monday was beautiful. It was wonderful. Shh, don't tell nobody. I did your work today. I had some errands I had to take care of. So work wasn't important to me today,
LaFell.
especially when you've been there 39 years. Trust me. I'm making this week extra sharp because I am off on Friday and Monday. So you best believe it's going to be a nice weekend. Not going anywhere, but we're going to see what we can do with this page and how fun we can make it. How much fun we can make it. Okay, let me see. Tonight's reading. let me see this.
Guys, I won't have this one up.
Sylvia,
Huh?
there is nothing attached. Do you know that?
I attached it.
It says tonight's reading. All I see is your name, unique, and there is nothing attached.
What is going on here? Hold on.
I don't know, but maybe they want me to talk to the chat a little bit longer. Okay, there's 92 in here. When I go and look at that like, I hope it's near 92 people. Let me see. 60. So we're still off by 32. Well, we did receive 3 more thumbs down. I'm not going to give you much attention because I know that's what you want me to talk about. You can probably get a thumbs down on purpose. So whatever. If the content or if we deserve thumbs down, start coming in here listening to us. Stop coming in here eavesdropping. Stop coming in here being a spy. Stop doing that. Stop trying to develop content for your page and take it back and stuff because you know what? Yeah, competition is coming and this page is about to blow up this channel. So stop coming in here and trying to see what it is unless you go out there and find another berry. Y'all about to lose. Yeah. I hate going there. I don't like to get there. Okay, let me read some more chats until Sylvia sends it to me and attaches it this time.
I did attach it.
Ready, red. No, I'm telling you.
I promise you, I attached it.
Okay, so well, they must have removed it then because there was nothing on there. Not at work, however, at home first.
Check it
Yeah,
now.
it'll let me know when I come. I'll get a notification.
Okay.
Not at home. Okay, ready, red. Not at work, however, at home. First I was, however, not. I rarely go on Facebook. Exactly.
Look at
Hadn't been on there so long.
Look what Sin said.
What Sin? Let me see what Sin said. I know I stopped in July, and I feel good. Trust me. Let me see Sin.
Look on the page, on the front.
On the front?
Yeah.
Wait, I was way up in the chat, so if she said something, I had to come down to the bottom.
On the panel.
Hold on. Let me see. Yeah, and the only reason why I couldn't delete his thing, only reason why I couldn't delete my Facebook page is because when I set my Facebook page up in 2009, it was under a different phone number and a different email. And so I try to let the administrators know, okay, I no longer have that phone number. I no longer have that email. And they send back, well, we're going to send your reset to that phone number and to that email. Well, obviously, they don't want me to delete my page, right? Because if you're telling them you don't have that, and then they ask you, well, what password have you used on that? I gave them the password. It was confirmed with password that I used before. They still said we're sending a reset to that email and to that phone number. Isn't that stupid? So that just means that they don't want me to delete my page out because I was about to delete it all the way out. I was trying to take all my pictures off, but they stopped that too. Okay, let's see this again, Sylvia. Okay, now it's attached, Sylvia. Okay, so let me just get it over to the PDF documents. All right, let me save to my background. So add to home screen. Boom. Okay, we good. Cool. Thank you. Okay, let me see what else. Let me catch back up on some of you good people's chat and see how many people
I'm trying to wait for everybody to
71 likes, six thumbs opposite.
I'm trying to wait for everybody to come back in.
It's all good. 71 likes. We got 97 in here. Please hit that like button. Share. How many people did add it to your subscription? Did it just reach 10,000 or a little more and just stall? People, I gave away $100 yesterday to her 10,000 subscriber. 10,000 got $100, and we still. She's gonna get a number. I mean, she'll let me know how many more she needs, and there's another $100 to get it at 10,300. So there's another $100 on the line from Mr. Fo Smiles. Yes. Okay, let's see here. Okay, Mondays, Red Chew. Let's see. Ashton, us all. I'm sorry, I'm not knowing, even though I'm pushing the town. Okay. Moses Gunn, my stepson is JJ. Okay. Sounds like the house. Not at work, however. Okay, read that. He can make some money. Nova. He can make some money. I can tell my mama he's from one of the old doo-wop. Nova, my dad sung with the old doo-wop group, the Platters. So mm, rest in peace, Papa. Miss you big time, man. Oh, sorry, man. Praise God. Man, actually, something. Sorry, I keep pushing. Enter. Mm. Sylvia, your hair is cute. Latanya says. Okay, good. I thought it was quiet and it had booted me out. Okay, let's see where else. Where we stop at. Beauty Sand. Which reading y'all doing tonight? I'm late. Hit that like button. That's right, Kimberly. Let them know. Hit that like button, please. It's great news. Jeez. Looking through. At Ready Link. Thank you. Thanks, everyone. Latanya Brown. Love the Barry White voice. You welcome. Thank you. Thank you. Thank you. Fire 100. Yes. Thank you so much. It was a gift. It was a gift. It was a gift. I'm gonna tell you.
Yeah.
Let me tell you a trick real quick about. Well, not a trick. A story real quick about my voice. So. I didn't want it deep. My father's voice was deep because he was a baritone in the group. So I had no idea that my voice was going to get deep, right? Because when I was in like, what was that? Uh, Was it junior high and high school? I can't even hardly do it because I used to talk like this, like it was all cool and like the ladies wanted to hear that, and so I would speak like this, but it sounded like a weirdo. I thought I was cool like that, and then my voice just kept getting deeper and deeper, and so I started getting compliments on my voice. It was like, you really have a nice voice, Barry White. I heard Barry White so much. If I had $1 for every time I heard Barry White, I would have been retired. So I kept hearing that. And when ladies would say it, it was like, okay, cool, but you never think nothing of it until it's like, okay, the lady said it. But then when my vendors, these are the people that I purchased from for the fire department and stuff, and when they started calling me, yeah, that's Mr. Smooth on the line. That's Mr. Smooth, man, you got a smooth. So that there was like confirmation. The ladies were confirmation. Anyway, it was already confirmation, but when the guys started saying it, and they wasn't saying it in like a LGBTQ way, but they were saying, "Man, you need to be doing something other than buying from us." And that was the time. Then I wasn't. That was the time when I was a buyer and not a supervisor yet for buying, for purchasing. So, but they were telling me so. Yeah, it was interesting. It's like, man, you wasting your time. You really wasting your time. And I always told him it's all about timing. And that's how I still feel. It's all about timing. When the time is right, it'll happen. Tee hee hee. Yes, Lady K. Yes, Charles. All right. Oh my God, Rhonda. Congratulations, Sylvia. It shows to the dome. The show did. I am back. Beauty. And hello, love. Sylvia. What are we doing? Well, we're waiting to read.
Okay. I need all
We're
my
waiting
readers
to
to come into the chat. Come on
come
now,
on in
readers.
there. Come into the chat or come onto the
No,
stream.
I mean, you know what I mean. You know what I mean.
Well, no, I'm just making sure. I'm just making sure.
You know.
If it come to, then it'll be
Look,
like we're in here,
I was
right?
weak. I'm eating French fries.
Elizabeth Bell at Rhonda. Well, ladies are flirting with Kenneth. If it gets
They all
this
flirting
page,
with the
whatever it
man.
need, let them flirt, Elizabeth. Come on, my sister. uh, who was that in there that put my information in there? If you want to follow me, you feel free to follow me on Instagram. Mod, put that up, the information up. I think you still have it.
Unique. I mean, not unique.
Who,
You digging
who,
me? Where's she at?
yes, you digging me at? Oh, she ain't even in here yet, I don't think, huh?
Mm-mm. She be in the bushes.
Yeah, if you're in the bushes, put that in there. Elizabeth. Mm, 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 mm.
Rhoda, come on in.
Du-
Rhoda, did you get the email? See, I told you, there go you digging me. Told you she'd be in the bushes.
Back to the bushes. Listen, look at you. She be on it. She be on it. Yes, you do. So that's my Instagram. If you're interested in following me, um, it's nothing all big, but you can at least start following me before I really
Hey, Cool P. There goes
blow
my girl,
up.
Cool P.
What's that? Where's Sylvia? Y'all, she's right here. You dig me? You can't hear her?
Oh, you want to see Sylvia? Hold on, you digging me. Hold on.
She got that hair thing
See,
going.
I am, y'all. Coolio's gone. Buckwheat gone.
She got that hair thing going,
Farrah's here. Isn't that Sylvia?
Yeah. Good loving body rocking, knocking.
All right. Thank you for my super chat. My super sticker.
Okay. Let me check the likes. Can I check the likes? We got 96 in the chat and we got 84. Okay. You're making up from that 30 person gap. So we got 84 likes. We have 96 people in here, minus the 7. And that would give it 91. So there's still 5 people.
Rhoda, you're not getting it? Hold on, let me go get it from the inside.
I told you, Sylvia.
What?
No, that.
Getting the link.
Oh, the link, or the attachment. So one is 91. So there's at least 5 people because we do have 7 of the opposite like that's in here, and we have 100. So we at least need 6 people that haven't did it yet to go hit that like button, please. Help a sister out, help a brother out. So you digging me, Sylvia? Something wrong with your chicken? I don't hear the crunch like Tyson chicken.
Oh, I don't like crunchy chicken. I don't like crunchy chicken. I like my chicken soft.
There's Elizabeth. It's the truth, though. Yes, she is. She's one of the truth there. I don't want nobody to get jealous thinking that.
Look at your email. Look at your email, Rhoda. Look at my chicken. Look at my chicken.
Yeah, chicken.
Huh? You want to hear the crunch? Hold on. How about that?
Yeah, they miss Johnny. Who's Johnny? Jeez, digging me.
Check your text messages, Rhoda.
You're digging me. 'Cause I'm staying safe with Elizabeth Bell.
Look at your email, Rhoda.
I'm in.
You got your email?
Thompson.
Yeah, I got the email.
Samantha Nicole. One Koopy. Latrice Robinson. Oh Lordy. Playing around. Everything. Victoria. She's scrolling to catch up. Elizabeth probably. No. Elizabeth, she's probably cleaning. That's from you digging me.
What is wrong with you?
Hey, I'm just trying to have some fun. Sneak out that voice a little bit since they say I can't sing, but I'll do it in a comical way. hmm Moses gone Afro Sheen. Hey, they ain't paying me, man, but I'll shout it out. Afro Sheen and Afro Sheen Cosmetics. hmm hmm
All right, here we go. I think we got 4 people in here. What happened to our girl?
Who? Geddes?
Geddes.
Geddes?
Mm-hmm.
She come back?
Yeah.
She not back yet?
Mm-mm.
She probably put that aluminum foil on her. She's probably putting the aluminum foil on her smartphone. She'd be having issues with it. So put the aluminum foil and point to the ceiling and come on back in here.
Where's Robbie?
Because I remember Afro Sheen commercials when I was little. That's right, because that was from the Soul Train. Mm-hmm. Enough of the cup. Say, what happened to Daddy? LOL. I don't know who's Daddy. Who's your daddy? So I'm not your daddy. But who's your daddy? Mm-hmm. Who's your daddy? 93 people and 102. That's right. So that means, hey, 102 people. 102 likes. That's what's up. 102 likes, and we only got 93 in the chat. So at least somebody hit it before they got out of here. Hit the likes, that was. Mm-hmm. 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 What you doing, Sylvia? Sylvia?
Yes.
What you doing?
Wait, I was texting Missy to see where is she?
Mm-hmm.
Where is she?
Okay, I forgot. You said look over here into the chats. Okay. What page? What are you reading? Okay, I'm looking over here into the chats. Was it something special I was supposed to have been reading over here? Sylvia? Was there something special I was supposed to be reading over here on this side?
Mm-mm.
Oh, okay. I thought you said
somebody had said something to you, and I was putting it on the screen. All right, yeah, you're ready to start. She could just come in. Oh, Rhoda just left.
Somebody.
Oh my God.
We lost somebody. See, that stream be booting out, but you know what? I caught on to what it was. I know that as soon as you throw that stream in there, I reboot my phone. So that worked. Mm-hmm.
All right, yeah, you ready? Daddy Lolo.
What page are we on?
Huh?
What page are we on?
We starting from the beginning on that one.
Oh, okay.
All right, everybody's here. All right, Daddy Lolo took some time off, y'all.
Who I'm playing? That's my character.
I know. Who is who?
I'm Geddes, right?
Mm-hmm.
Okay.
Oh, Geddes, this is still good. Oh, okay. I don't know what I was thinking. Okay.
You got it open?
Yeah, I got it. Mm-hmm. Let's see, can it? Okay. Got it. Who's the courtroom deputy?
Unique.
And the court?
Rhoda.
Mr. Judge. Who's a scholar?
Who am I?
Yeah,
You-
Mr. Scholar.
We need
School.
Nicole.
You could be Becker.
Miss Blank Becker.
You could be
Mm-hmm.
Becker. I'll be Scholar because it's not that much.
Okay.
Okay.
Okay, y'all ready?
Who
Yeah.
am
Let's
I?
go. Hmm?
You are Becker.
Okay.
You Nicole Becker.
No. Huh?
No. No, I'm not Becker.
You are
Oh,
Becker. You're
Oh,
Becker,
okay.
and then Geddes is Geddes.
Who's the court
Okay.
deputy?
What page?
It's
Oh,
page
the
3.
beginning. I'm
page
Court
sorry.
three.
deputies. You know, could be all both of them. All right, guys, y'all ready? Let's get started.
Let's go.
Okay.
All rise.
Everybody can have a seat.
This is criminal cause for a pretrial conference, docket number 15-CR-286, USA versus Robert Kelly. Counsel, state your appearance. Government first. Elizabeth Geddes, Nadia Shahada, and Maria Cruz Melendez for the government. Good morning, Your Honor.
Good morning.
For Mr. Kelly, Devereaux Canick, along with Nicole Blank Becker, who is appearing remotely, Thomas Farinelli, and Calvin Scholar. Good morning, Your Honor.
Good morning. Good morning. Mr. Scholar, welcome aboard.
Good morning, Your Honor.
A couple of things to take care of today. I'm just going to remind you before we go into the motions in limine. Let me first ask Miss Becker, are you staying with us on the case?
Thank you, Judge. Judge, I did, and I hope you receive a letter this morning
Yes.
from the doctor.
Yes.
Did you get that, Judge?
Yes.
Okay, great.
Finish.
Yes, Judge. Based on the doctor's assessment, as of today, I am allowed to travel, so I will absolutely be there.
Okay, great. All right. Second thing, jurors have been, so just related to what Miss Becker said, I take it you're no longer requesting an adjournment. Is that right?
We're up and ready to go, Your Honor.
Okay, good. The second thing is that I'm sure you're all aware that jurors have been filling out questionnaires, and so, as I directed earlier, we need to have your list on those jurors upon whom you agree. The ones that you agree should be excused. We need to have those tomorrow. So the ones you agree should be questioned, and the ones that you agree should be excused. And then I'm sure there will be some that fall in the middle, so that we have to have by tomorrow. Just in terms of the trial schedule, it's my plan to take Fridays off, except for those weeks where we have holidays. We have a number of holidays in September, religious holidays. And so the weeks that include a religious holiday, we'll work on Friday that day. And I don't have them at my fingertips, but I think they're pretty easy to find. Okay?
Yes, Your Honor. To be clear, the Friday before Labor Day, we're off?
Would you like to be?
Yes.
Well, I don't think there's anything else that week.
Right.
So, yes.
I apologize, Judge. I can't hear Mr. Kenneth speaking. I can't hear him.
Okay. Just let's be mindful.
Sorry.
That's okay. Just be mindful of the microphone. Mr. Canick was asking if we had the Friday before Labor Day, and I don't think there's any other holiday that falls then. So the answer is yes. So we'll have that.
And Your Honor, I'm sorry to interrupt.
That's okay.
Will you also sit on August 20th since we have a short week, that first week, Friday the 20th?
Is it a Friday?
Yes.
I think it's a good idea to make as much use of our time as we can. So yes.
Thank you.
Okay. Now I just want to go through the various motions in limine. Some of, at least with respect to some of the submissions, are under seal. And so I'm just reminding the parties to be sensitive to that. I'm going to begin with the government's motion to admit various acts that are not charged in the indictment, but that the government asserts are evidence of the pattern of racketeering. And just as a reminder, the time frame for the pattern of racketeering is from 1994 to the present. Mr. Farinella, in your objection, there were just a couple of things I want to clarify, because you're saying that you had insufficient notice under 404 paren B. I mean, that applies to when the government is just seeking to admit evidence of bad acts, which is really not what they're seeking in this case. But if you had the discovery material and 3500 material for quite some time, which includes the materials to which the government refers, you're not saying you didn't get the material, are you?
Your Honor, what I said in the motion is that the incidents that they are attempting to introduce into evidence, the 3500 material related to the specific instance, were provided just recently.
February, I thought.
Well, there was an additional disclosure made on about last week. This week, I'm sorry, Monday, with additional 3500 material relating to these acts.
How many of them? All of them? I think you have to be specific if you're claiming you were blindsided, which is what you said. So what specifically did you not get until recently?
Well, Your Honor, we only obtained additional John and Jane Doe's, that information yesterday at the time.
Do you mean the names of them?
There's an additional 17 Jane Doe's, and there are 2 additional John Doe's.
I just want to make sure I know what we're talking. I'll go through each one. But my regulation, and I actually checked the docket sheet before today's appearance, was that the representation by the defense was that you knew who all of the Jane Doe's were. Are you saying that that's not accurate?
So, Your Honor, I'm not saying that's not accurate. That is a fact accurate.
Okay.
In the underlying indictment, Your Honor, there are 6 Jane Doe's. We have obtained the identity of those Jane Doe's. However, in the government's motion, they have unveiled 17 more additional Jane Doe's and 2 additional John Doe's.
And are you saying that you didn't know the names of them until recently, or that you didn't have any information about the acts that are connected to them?
To the extent, first, your first question, Your Honor, the names. The names were only revealed to us. The actual specific names as to each of the Jane and John Doe's were actually provided to us yesterday.
Okay. Is that accurate? I just want to ask the government.
We provided a full disclosure of every name of the Jane and John Doe's yesterday. In addition, we had provided the names of several of the Jane and John Doe's previously, but we didn't identify them as John Doe or a Jane Doe because there wasn't a motion related to them. We just disclosed previously to defense counsel in the 3500 material.
What about the underlying acts?
The underlying acts were the subject of 3500 material disclosed in February, with the exception of, I'm looking at them right now. We did provide some additional 3500 with respect to Jane Doe 11 and 12, which we obtained. Specific instances were provided just recently.
Okay.
Oh, wait, I'm sorry. After the initial February disclosure, so we provided that more recently.
Okay.
And we provided additional evidence of some of the other acts, evidence that we seek to admit, but the 90% of what we seek to admit, we had previously disclosed the substance of those allegations in 3,500 disclosures and discovery disclosures.
So you acknowledge that, don't you, Mr. Farinella, that you had the substance of what these claims are?
Yeah. I mean, to the extent that they were provided, yes, in the 3,500 material.
Okay, but that's what I'm trying to figure out. What are you saying that you didn't know about that is just a complete surprise to you? Anything? Or is it just that there's additional? So the choices are, I never heard this before, I heard part of this before, but I didn't have all the facts in connection with it, or I've heard the whole thing before.
I think your second choice, Your Honor.
Okay,
I've heard it to an extent, but there was no connection to the facts to the actual witnesses themselves.
so you just didn't know the name of the person that was associated with the particular allegation.
Well,
You know, let's go through them all because that's what I'm going to do anyway, and then you can tell me. The other thing I'll say about notice is that I'm the one who set the motion schedule for motions in limine, and I don't. The only thing I recall about that is that the defense asked for extra time, which I granted. So that was what the schedule was. And if there was some need to have it sooner, I'm sure you would have told me. All right. So what I'm going to do is just go through these. And if I miss one, because I did get a lot of submissions, I'm sure you'll let me know. So the first one has to do with the claims related to Jane Doe number 1. And these are allegations about conduct in 1994. The government position is that this evidence is direct evidence of the enterprise, that it provides the motive for the charge in racketeering, for the conduct in Racketeering Act 1, and that it is inextricably intertwined with that. And so it's clearly relevant and it clearly shows a motive for Racketeering Act number 1. So that is admissible. That's not something that was a surprise to you, was it, Mr. Farinella?
no, Your Honor.
Okay, the next one.
I'm sorry.
Sorry, Ms. Becker, go ahead.
May I just address that one briefly, if I could, please?
Sure.
Judge, well, I believe it states something to the effect in our motion as well. While understandable that clearly Jane Doe number 1 is a listed Jane Doe, of whom we knew about, no doubt. I believe what we put in our motion and what we believe is that although certain parts of it are certainly relevant, there was a lot of statements made and requests to come regarding the circumstances surrounding the marriage and so forth that we believe are more prejudicial than probative.
Well, let me just say this generally about all of
Sure.
this evidence is that, I think I've said this before. I don't have the 3,500 material. I don't know what the testimony is going to be. I can say generally that this is relevant and it is related to the Racketeering Act. It provides the motive, and in that respect, it is clearly relevant. And not only does it provide the motive for Racketeering Act 1, it is also evidence of the allegation about the enterprise and the methods and means used to perpetrate the enterprise. So in that respect, it is clearly relevant. Obviously, with all of these things, I'm not going to permit hearsay. The evidence has to be in an admissible form. But the point of my rulings today is to tell you what's admissible and what is not. I don't think I have to go through chapter and verse with this group of experienced lawyers about the form in which the evidence takes. So let's just keep that in mind.
Thank you, Judge. I agree. Thank you.
Okay, the next act has to do with Jane Doe number 7 in 1991. This is pre-pattern or pre-racketeering enterprise evidence. I just want to hear from the government. I know your position is that it is evidence of the means and method, but it takes place before the racketeering. The organization is alleged to have begun. And so my question is, why does that come in?
Honor, Jane Doe number 7 is prepared to testify that in light of her relationship with the defendant, which included the fact that they had sexual contact with each other when she was a minor, she was in a position to view the defendant engaging in sexual activity with Jane Doe number 1. So it is part of her background, and I would say her history in extra capability intertwined with that information is extra capability intertwined with her account of how she knew the defendant, why she was with the defendant when she saw the defendant engaging in sexual activity with Jane Doe 1. God.
Let me ask the defense, are you going to deny that there was sexual contact with Jane Doe number 1? Wasn't he married to her? Is that something the defense is going to dispute?
No.
No. Well, if they're not disputing it, then I'm going to exclude the evidence of Jane Doe number 7.
Wow.
Your
Why
Honor,
they didn't dispute that?
I know. Your Honor, just to be clear, are they
Hold on.
conceding they are not going to dispute that they were engaging in sexual activity prior to their marriage? Because at the time Jane Doe 1 was 13 to 15 years old. I don't think that's something that they're prepared to.
We are not, Your Honor. So I want to understand here. So the government's position, just so I have it clear, that Jane Doe 7 or 17?
7.
Okay, that clears it up.
Okay.
But no, we do not dispute. We're not prepared to concede at this time, Your Honor, with regard to Jane Doe number 1.
So if Jane Doe number 1 witnessed the defendant,
Jane Doe number 7.
sorry, Jane Doe number 7 witnessed the contact with Jane Doe number 1. Wait a minute, let me stop. Jane Doe number 7 is who? Who is that?
Javante.
Oh, okay. Jane Doe number 7 witnessed the contact with Jane Doe number 1 is clearly relevant if you're going to dispute it. You can cross-examine her about it, but if that's not something that is directly relevant to the first racketeering act.
And I do believe Jane Doe number 7 is one of the Jane Does that just recently revealed. I don't recall if seeing her.
That's correct.
In the original 3500 material, so I would ask the court before making the ruling if we can at least just have a very short window of time to review.
Okay.
Because there are a number of new disclosures, and again, we have a limited amount of time to respond.
That's fine. If you want to take some time to review that and just submit a letter on that, that's perfectly fine. But I think, do you want me to give you a deadline for that?
Sure.
Can you give it to me in, let's say, what's today? Tuesday? Can you give it to me by the end of the week, by Friday?
Yes, Your Honor, I can.
Then can the government, I hate to ruin your weekend, but can you respond by Monday?
Yes, Judge.
And if there's any reply that you wanted to file, you can just do it the next day, okay?
Understood, Your Honor. Thank you.
Sure. All right. The next request has to do with Jane Doe number 8 in 1994. The government proffers Jane Doe number 8 was in concert of the defendants and was directed to go backstage by the defendant's associates, and that the defendant had sexual contact with her. As the government has proffered before, they represent that this is direct evidence of enterprise in its means and methods. This is an example, and maybe I don't have to repeat it, but this is really not propensity evidence. This is evidence that is offered to show the existence of the enterprise and the methods undertaken to perpetrate the evidence. So it is relevant and it's not unduly prejudicial. It's no more inflammatory than the charged offenses, and so that one is admissible. The next one has to do with Jane Doe number 9 in 1995. This has to do with racketeering acts 12 and 14 in counts 6, 7, and 8. I don't know to what extent the defense has considered stipulating to some of this evidence. This is regarding the transmission of sexually herpes. So I think the question is, the government is saying that this is relevant to show the defendant's knowledge of the condition, but I think some of this, if there's a stipulation about that, it becomes less relevant. Is that something you like to put in that letter also?
Your Honor, I would ask the court to consider this. There are a number of disclosures of Jane Doe's that were recently disclosed with the 3500 material. Perhaps in an effort to try to expedite this process, we can just have the short window period of the time to have substantive review of that material, and at that point, we will certainly, if we can, attempt to meet and confer with the government to see if we can stipulate to any of the issues that are.
Okay.
That we agree on.
Okay. Let me just say, in the absence of a stipulation, it's relevant to one of the charges, and so I'm not requiring you to stipulate. Sometimes people do agree to this in an effort to move things along. So it's just something I'm putting out there. So we'll put that in the category of things you're going to let me know in that letter on Friday, okay?
Thank you, Your Honor.
The next item refers to Jane Doe number 10 in 2001. This is similar to the, somewhat similar. It's related to the previous one, but it is also, I take that back. I've got it's not. This has to do with Jane Doe number 10 being recruited by an associate at a concert when Jane Doe was 16. And at some point, Jane Doe became concerned that an encounter with the defendant was filmed. And so she reached a settlement with the defendant on that matter. Now, this is not one of those things about which you didn't know. Is it, Mr. Farinello?
I'm reviewing. I'm trying to understand, what does all this have to do with after he was acquitted in 2008? But we can continue.
Oh, take your time.
Bro, I didn't do nothing, bro.
The original 3500 material names, and I do not believe I see.
You didn't block, duck, swing back.
Miss Geddes?
Your Honor, excuse me. We provided evidence of the contact in Rule 16 discovery. It's not been disclosed in the 3500 material.
I'm sorry. It was disclosed in Rule 16, pursuant to Rule 16?
That's correct.
Okay.
But not Rule 3500.
Okay.
Not 3500, excuse me.
So the question is, I don't think there's any question that it is relevant because it, again, is evidence of the enterprise and its means and methods, and the settlement, the fact that it was settled, I think is evidence of the effort to perpetuate the existence of the enterprise. Because were that made public, it would certainly have jeopardized the existence of the enterprise. I do not believe, so it is relevant. It is not unduly prejudicial because it is, like some of this other evidence, no more inflammatory than the charged offenses. So that is admissible.
Your Honor, might I, if the court is going to allow testimony or evidence there was a settlement, then we're going to ask the court for curative instruction at that time.
Definitely.
Okay.
And I should have said that at the beginning, that there may be instances that I've ruled that are admissible that will require curative instruction should the parties request it.
Thank you, Your Honor.
Okay. Jane Doe number 11 and 12. This I think we can put in the same category, Mr. Farinello, of those things you're going to take a look at.
Yes, Your Honor.
Okay. The next has to do with Jane Doe 13. And this relates to the conduct that occurred in 2006. The evidence is that Jane Doe number 13 was 15 years old, met the defendant at a concert. This falls in the same category of relevant evidence that tends to show that the enterprise existed and is consistent with the methods and means that are contained in the indictment. It is, like the other evidence, not unduly prejudicial, whatever that is, and no more inflammatory than the charged offenses. So that is admissible. Now the next category of evidence has to do with John Doe number 1 in 2006. Is John Doe number 1 testifying? That's my question to the government.
Yes, Judge.
What is the general, aside from the evidence you're seeking to introduce, what is the general nature of his testimony? Is he testifying about the existence of the enterprise?
He will testify about the enterprise itself, as well as the means that the defendant through minor victim, and the manner in which the defendant introduced him to other females and directed those females to engage in sexual activity with John Doe number 1 in the presence of the defendant, which is very similar to some of the forced labor allegations involving Jane Doe number 5, where the defendant engaged in a pattern of manipulation and physical abuse to ensure that Jane Doe number 5 would participate in all of the sexual activities directed by the defendant, to include sexual activity with other men and women.
Now, I just want to, this was information that was turned over in February.
That's correct.
And is that correct, Mr. Farinella, that you received that in February?
Certain aspects of that we received in February. We also received additional disclosures just recently, I believe.
I don't think, with respect to perhaps in trial prep, we have had an additional meeting with John Doe number 1, but all the allegations that are described in the government's motion were previously disclosed in the 3500 production in February.
All right. You agree with that, Mr. Farinella?
Yes, Your Honor.
Okay. Now the allegation is that John Doe number 1 was 17 and that the defendant promised to help him with his musical aspiration, and that the defendant began a sexual relationship with him. The government's basis for admission is this is direct evidence of the enterprise and its means and methods.
Sylvia.
And it includes a common scheme or really more of a modus operandi, which is promising to help young people in the music industry in order to lure them. The evidence is certainly relevant because it demonstrates the methods that were used to perpetuate the evidence. I know that the defendant has complained that, or I'm sorry, has objected that it is more inflammatory than the charged offenses, but the charges include allegations about same-sex relationships. So it's really not more inflammatory than that.
She quoted.
One of the allegations is that the defendant directed young women and girls to engage in sex with one another. And it's not more inflammatory than the charged offenses. I don't recall what's in the jury questionnaire. I could look at it, but you had the information at that time, just in general, that there were allegations of same sex, that the defendant directed young women to engage in sex with other young women. You had that information, correct?
That information, Your Honor?
Okay. I mean, this isn't really different than that.
Well,
what we can do is pose additional questions to the prospective jurors about this particular, just about those allegations in general, appropriately phrased questions if that's your concern.
my concern is the jury is not going to pay attention to anything.
Just
I'm
say
sorry, I
not
read the wrong
guilty.
line.
Exactly.
I read the
She
wrong
said
line.
it.
Well,
She said
Exactly.
There was inconsistency. They're supposed to vote not guilty.
Exactly.
Sylvia, we can hear you.
well, yeah, she was
Sorry.
making a comment. Well, that was the concern that we have raised, Your Honor, but I think there should be an appropriate question raised to the jury with regards to the issue, yes?
Okay. So with that proviso, what I'll do is take submissions from the parties on the questions that you want me to pose to jurors regarding. And I'll talk to you in a little while about just the general process of how we'll be doing jury selection. But if you prepare those questions for me, my suggestion, maybe you don't need my suggestion, but my suggestion would be that you make it cover all of the issues in this area. Because the whole point is to prepare them to make sure that people don't harbor any particular feelings that would make them unable to serve on a case like this, okay?
Understood. Thank you, Your Honor.
All right. The next issue has to do with Jane Doe number 14 in 2008. This has to do with unlawful imprisonment that Jane Doe number 14 went to see the defendant in Chicago, and during the last trip she was there, she was not permitted to leave a room. She was eventually permitted to leave after she threatened to call the police. Let me make sure. Do you object to the admission of this evidence, Mr. Farinello?
Yes, Your Honor.
What's the basis for your objection?
Again, this was the limited amount of information that was disclosed to us in the 3500 material, was expanded upon and regarded to, I believe it is Jane Doe.
Let me just suggest something to you, and maybe you can think about this. In some regard, the fact that somebody says they're going to call the police and then they let her go is helpful to you. So I don't know if that's something you want to think about or not. We can put it in that category of things that you're going to address in that letter.
Yes, Your Honor.
Would you like to do that?
Yes. Kitties. Kitties.
I'm on mute, sorry. Your Honor, just to be clear with respect to that one, 3500 material as of Jane Doe 14 was disclosed in February.
Okay. The next category of evidence has to do with employee number 1, who is testifying, correct?
Yes.
In Jane Doe number 14, and in general terms, the government proffers that Mr. Kelly met Jane Doe number 15 when she was 17 through her talent manager, who is employee number 1, correct?
Yes.
And that Mr. Kelly was going to mentor Jane Doe number 15 in the music industry. She filed a police report alleging sexual abuse and retained a lawyer. Jane Doe number 15 will not be testifying. Is that correct?
That is correct.
Well, why not? In the allegations that Mr. Kelly told employee number 1 that she had to make a choice between him and Jane Doe number 15, and said words to the effect of, you have to be careful in these situations because people end up going missing. Employee number 1 went to a lawyer's office and was given an affidavit which said that she had not seen the defendant have sex with Jane Doe number 15, give her alcohol or slap her, and that she signed the affidavit. Is Jane, again, this is because I don't know the particulars of what specifically are you asking? Do you want to elicit from employee number 1?
The crux of what we want to elicit. The what? Cracks?
No, go on. Crux.
Oh.
Go on.
Cracks. The
Crux, like a crutch.
oh, okay.
Go on, finish.
What we want to elicit is the fact that the defendant threatened employee number 1 that if she did not go along with what he wanted her to do, which includes filing or signing this affidavit that was prepared, adverse consequences would come to her. So again, it was a means and methods of the enterprise which used to ensure that the defendant had control over both his employees as well as other victims.
I guess what I'm getting at is that you're not seeking to introduce statements by Jane Doe number 15 to the lawyer, are you?
That's correct.
Okay. So, and what about the fact he paid $400,000 to her? That's not coming out through employee number 1?
It won't come out. It won't come in through employee number 1. We may seek to introduce it as part of the use of settlement agreements to control what information is disclosed beyond the defendant and the victim.
Well, I think for our purposes here today, the employee can certainly testify about our own interactions with the defendant, but I don't understand you to be asking to admit evidence of Jane Doe number 15 statements to number 1, correct?
That's correct.
All right.
Your Honor, also just to ensure for the record, we have not been giving any specific information as to the various employees and witnesses that have been identified in terms of specific references as to who they are.
Have you given the names of who employee number 1 is?
We have provided 3,500 material for each of these employees, which include their first and last names. I am happy to provide the defense counsel a list of precisely. Hold on one sec. My dogs are going to. Precisely in the motion who employee 1 refers to, but the substance has been disclosed, and a review of the substance would readily make clear who employee number 1 is.
It might not be a bad idea, just given the volume of the information that the defense has to deal with. I'd like you to give them a list of, I assume they know most of them, but give them a list of the names of the people and pseudonyms that applies to them.
We will, Judge.
All right, let's get that done by today, all right?
Yes.
Anything else that you want to say about that, Mr. Farinella?
No, Your Honor.
And if it's not clear, that is admissible in relevant evidence. The next one has to do with Jane Doe number 16, and this spans a period of time. Do I have this correct? 2006 to 2017?
That's correct.
The evidence, according to the government, is that Mr. Kelly began a sexual relationship with Jane Doe number 16 when she was either 16 or 17, and that she stayed with him until 2017. Apparently, I think the application is that she would be permitted to testify about the rules that Mr. Kelly enforced and what happened if there was a violation of the rules, and that she also was required to write letters that included embarrassing and false statements about herself. There's also an allegation that Mr. Kelly directed her to have sex with John Doe number 2, which was filmed. All right? Let me just make sure that this is not something that's news to you. Is it, Mr. Farinello?
No.
So this, again, is direct evidence of the enterprise's means and methods, and particularly over that long period of time. So it's surely relevant. It's surely admissible for that purpose as direct evidence. Assuming that Jane Doe number 16 testifies as the government represents, is also evidence of the control that was exercised over the various, whether they are victims or associates of the enterprise, in the ways in which control was maintained. It's not more inflammatory than the charged offenses, and so that is admissible.
Your Honor, just to be clear, even if Jane Doe 16 does not testify, Jane Doe number 5 witnessed some of the physical abuse and other psychological manipulation by the defendant as to Jane Doe 16 and Jane Doe 17, and that is relevant to her understanding of what would happen if she violated his rules. So it also goes to forced labor allegations with respect to her.
So your anticipation is Jane Doe number 16 will not testify?
I'm not saying that. I'm saying even if she does not testify, I think it is still relevant and admissible because Jane Doe number 5 firsthand saw and heard what was going on, and it was relevant too. It was the ways in which the defendant maintained control over Jane Doe number 5 was shown her what would happen to her if she violated a rule in the same way that she had seen Jane Doe number 16 and Jane Doe number 17 violate a rule.
Well, I'm making this ruling with the same obvious proviso that the evidence has to be in admissible form.
Yes.
So that would be non-hearsay, direct evidence, but the evidence itself is admissible. And to Jane Doe number 17, this is also the same pattern. And I take it you may make the same arguments with regard to that.
Yes, Judge.
I take it also, Mr. Farinello, that this is not something that you've just learned about, correct?
No, Your Honor.
It's not correct, or is it? Or it is correct?
It is correct, Your Honor.
Okay, that is admissible for the same reason. Let me just say, just generally, although I think this evidence is relevant and admissible as direct evidence of means and methods, there is an alternative basis for admission under Rule 413, which permits evidence of a defendant's prior sexual conduct for whatever purpose is relevant. That statute, though, the Second Circuit has made it clear that the 403 rules apply in evaluating it. And I don't think there's any question that he's charged with sex crimes. You're not disputing that, are you, Mr. Farinello, that the rule applies, the Rule 413? The question is just how the court balances it.
I think the court answered its questions. He's charged with sex crimes, Your Honor.
I just wanted to make sure there wasn't a dispute about that, because I don't know that you addressed it in your letter. I mean, it is different. It's a rule that's sort of an anti-propensity rule, but it does require the court to engage in a balancing process. But it is an alternative basis for admission. My determination on the ones that I've ruled admissible so far have to do with the direct evidence of the enterprise. Jane Doe number 18, is she testifying?
Yes, Judge.
Jane Doe number 18, this is from 2016 to 2017. The proffer is that she was recruited by one of the defendant's associates at a concert, and that she will also testify about the various rules and the consequences of violating the rules, which includes various forms of physical abuse. The allegation is also that she was required to, like one of the other Jane Does, to write letters that contained embarrassing and false statements about herself, and that she was required to have sex with others, including Jane Doe number 5 and John Doe number 2, and that those encounters were recorded. This falls under the same category of means and methods, and it is relevant for that reason. It also demonstrates at least the control that the defendant exercised over victims as alleged in this indictment. It is not more inflammatory than the charged offenses, and it's also intertwined as the other evidence. The other Jane Does who would testify similarly, it is intertwined with Jane Doe number 5's testimony, as I understand it. All right, the next has to do with conduct in 2018 and 2019 regarding Jane Doe number 6, that the defendant and his associates used threatening tactics in order to get Jane Doe number 6 to stop speaking publicly about Mr. Kelly and to drop a lawsuit. These tactics included threats in text messages, in person, and on Facebook to release compromising photographs of Jane Doe number 6. And again, this is not, I know you'll tell me if this is something about which you were not aware, Mr. Farinella, but you were aware of this as well, correct?
Yes, Your Honor.
Clearly relevant to the enterprise's methods, and it also demonstrates the willingness of the defendant and his associates to take steps to ensure the perpetuation of the enterprise. It is not unduly prejudicial. It is not more inflammatory than the charged offenses. The next thing has to do with the threats to Jane Doe number 19, and the threats were in 2018. This has to do with directing her to travel to Chicago and to sign a non-disclosure agreement. I mean, this is relevant evidence. It goes to the means and methods. But I think it is needlessly cumulative, so I'm not going to permit that to come into evidence. The next has to do with an allegation of bribery of a Cook County clerk in 2019. What? The allegation is that after this television show was released and law enforcement began to investigate the defendant, that the defendant and an associate bribed the Cook County, Illinois clerk to get information about legal action. Is this a charged crime anywhere?
It is not a charged crime, and just to be clear, on the recording, the crisis manager indicates that he had bribed a clerk. The defendant on the recording says, "Tell me how much," indicating his willingness to carry out additional bribes.
I'm not going to permit that to come in. It's marginally relevant. And this ruling could change if the door is open, which could happen in a variety of ways. But it's not clear to me how this relates to the enterprise, except I suppose it could be argued that it is part of an effort to perpetuate the enterprise. But I think under the circumstances, I'm not going to permit it. The next has to do with the prior criminal case in Illinois that in the allegation is the defendant attempted to influence the jury. Is this through John Doe number 1 or number 2?
It's through John Doe number 1. And Your Honor, the government's interest in introducing evidence is much more directed at the fact of the 2002 case and the duration in which it went. In addition, the government anticipates that as part of John Doe number 1's direct examination, because it does constitute impeachment material, we would also elicit the allegations or the fact that he admits that in 2008 he had access to a jury, and the defendant's response to that. The thing we are far more interested in introducing the fact of the 2002 charge, and that the defendant was on trial for, was under indictment for such a long period of time, and was ultimately acquitted in 2008.
Mhm.
What's the relevance of that?
Oh, wait.
I'm not inclined to permit it, by the way. I mean, it seems he was acquitted of something for whatever reason, and it doesn't seem relevant to the enterprise. Instead, it seems to me that it's directed to showing that he's sort of been under suspicion for a long time. And I don't see an admissible purpose for that. I mean, generally, the fact that somebody was acquitted of a crime, you would not be permitted to inquire into that. And I don't really see a good reason to permit it here. Obviously, if something comes out during the trial, that, again, doors can be open all the time, but I don't think that that's admissible. So I'm not going to permit that, okay? The next has to do with an effort in 2019 to obtain child pornography. Is this charged anywhere?
No, Your Honor.
I'm not permitting that either. It's not clearly relevant, although it has some relevance, but it is surely unduly prejudicial.
Mm-hmm.
And I also note, at least as far as I can tell, the recordings, to the extent that exist, is not even being confirmed that they are child pornography. So that's unduly prejudicial, and I'm not going to permit that. The next category of evidence has to do with audio recordings.
Hold on, y'all. You hear what she said? They're not child pornography. So all the extra stuff that these people were saying, it's right there.
Right.
Yeah, exactly.
Yep.
Exactly.
There was no child pornography.
Exactly.
No, they get on my nerve with all the stuff they be saying, spewing on the other side. It's right there in the transcript.
Who are them?
They seem to skip over there when they're reading, I guess.
I guess so.
Is that Dominique, one of the Jane Does?
Or is it?
Dominique was 16.
That's what I thought.
Okay.
And who's the
I'm
other?
sorry. Go ahead. Can you read that part again, Rhoda?
Okay. I'm not permitting that either. It's not clearly relevant, although it has some relevance, but it is surely unduly prejudicial. And I would also note, at least as far as I can tell, the recordings. To the extent that exists, it's not even been confirmed that they are child pornography.
You see that? Not confirmed they are child pornography.
But they've been having that information since what? January of 2020?
Yep.
So that's unduly
not confirmed that it is child pornography.
Yeah.
But they keep saying it's bull crap.
Exactly.
All these fools I've been on the other side keep making up stuff, and I get so tired of them because they're not reading the damn transcript. Excuse my language. I'm sorry.
Ooh.
I mean, they're pissing me off.
She must be pissed.
Come on now.
I know how you feel. I know how you feel.
Putting these narratives, keep saying stuff, and it's not there.
Child, right? Exactly. That they're children. He was dealing with children, and that they were young and all this mess. Please get out of here with that.
So that's unduly.
Because remember, there were 100 devices, child pornography. No, it was not.
Exactly.
And honestly, I think that 2019 stuff, I think they planted that.
They planted that bullcrap. Because when they went to storage the first time in July, there was nothing in there.
There was nothing in there.
In January, when she turned around and started being on On the prosecution side, all of a sudden they found this stuff inside the storage. Come on.
Right.
Exactly. Exactly.
Why ain't
Some
anybody?
storage places have videos. I wonder how they probably done got rid of it, but it shows, when you're entering the storage and all that stuff.
Yeah, but why ain't they questioning? There was nothing found when they went the first time, and there was stuff found the second time.
Well, that'll make them look. That'll make them look bad.
She claimed that she said she's supposed to be telling him where it was because she happened to see him going into the storage one time. She knew exactly what box it was and all that because y'all planted that crap in there.
Exactly.
Exactly.
Yep.
Go ahead. I'm sorry.
No, don't be.
But y'all see how she was not permitting a lot of things, and people go, "Oh, why didn't they bring this? Why didn't they bring that in it?" It's clear she said she's not going to permit it.
Exactly. Especially Jane Doe number 15. Jane Doe number 15 said she viewed and seen that he did not slap, hit, or do any of those things like that. And they said, so you're not going to have that in there. We're not going to permit that in there, right? The government.
That's I tell you.
Yeah. Anything that was favorable to Rob in there, they wasn't going to permit it and they wasn't going to have it. And the fact that they didn't have anything before this, after you reading, you see them going in back in 94, 96, and all that right there, especially after he was acquitted. So why would you want to go back there and okay, I'm gonna be quiet. That'll be for discussion.
I mean, that's true. My thing is,
why would you go back up in there for any of that? You're right. For any of that.
My thing is, if it happened before 2008, it shouldn't even be in this trial.
Exactly. Period.
It was set up from the beginning with him.
Yes, it was.
But okay, let's go back to his interview with Gail. He said that was in my way past. He admitted some of the stuff he did in the past.
Exactly.
But from the time he went to court, he was not doing that stuff.
Nothing.
Exactly.
Nothing. And after reading this right here, they didn't have anything. They didn't have anything on him. That's why they kept saying. But let's finish reading because that's going to be a lot for us to talk. A lot for us to talk about and discuss because this is good. Yeah, right here.
Sorry.
So that's unduly prejudicial, and I'm not going to permit that. The next category of evidence has to do with audio recordings that depict the defendant yelling and physically assaulting women. It says women, not woman, women. And those are clearly admissible as direct evidence of the methods. I'm so tired of this word right here, of the methods used to perpetuate the enterprise. And it is direct evidence of the defendant participating in it. It is not more inflammatory, if I hear that again, than the charged offenses. In fact, it is evidence of the charged offenses, and so that is admissible. Next category of evidence, I want to make a general observation about these applications to put in witnesses' text messages. They may become relevant if the witness is challenged with, is accused of a prior inconsistent statement. Some of them seem to fall under that ancient Hillman case from the Supreme Court from, let's say from a long time ago, that seemed to talk about her declarations of future intent, that she's going to a concert, that she's going to go to Chicago, that she's staying in a particular hotel. Those are sort of classic declarations of future intent that are admissible. They are non-hearsay. The text recounting things that happened on the other hand, and things that she did are not declarations of future intent. They don't seem to me to be, they are not excited utterances. They are not present sense impressions. So those are not admissible unless she's challenged about it. Or if she has a failure of memory and they are still not admissible, but she can surely have her recollection refreshed with them, or if she's challenged that she's making the whole thing up, they may come in that regard. So I think this is all to say that this is premature. So I think we will wait to see what happens. The same thing can be said about the employees' messages. Are the employees testifying?
Yes.
They may be, if the witnesses are challenged that this is a recent fabrication, they may very well be admissible in that regard. And so the employees' text messages, again, we'll have to see what happens at the trial. there are text messages from Mr. Kelly, which are, I believe there are. Is that correct, Ms. Geddes?
Yes, Your Honor. I'm sorry.
Okay, you're not challenging those, are you, Mr. Farinello? Mr. Kelly's text messages? I mean, they are statements of a party opponent.
I mean, to the extent that they've been established as his text messages, they speak for themselves, Your Honor.
Okay, I'm just making sure. I mean, is that going to be a challenge? One thing, just sort of as a general matter, if you can resolve things without the need to call phone company representatives, if you're challenging whether they really are his messages, by all means, go ahead. But as exciting it is to hear a witness testify about it from the phone company, I think our lives would be complete if we don't have that. So if you can work out those kinds of things, I think it's better for everybody. All right. So that's really what I have to say about all those text messages, that it is just early to say. I like the next category of evidence has to do with what's been termed an electronic note that Jane Doe number 5 wrote in 2018 that appears to be a list of rules. I'm just going to ask the government to remind me of what the circumstances under which that note was created.
The government executed a search warrant at the defendant's residence, and there a cell phone was found that had been used by Jane Doe number 5. And on that cell phone was the electronic note in like the note section on an iPhone.
Is it your position that that was in the nature of a reminder to herself about what the rules were?
Based on statements made by the defendant.
Okay. Now, I'm not sure I understand. So there's a search warrant that's conducted at the defendant's apartment, correct so far?
Yes.
There's a cell phone that was used by Jane Doe number 5, also correct?
Yes, Judge.
And in the cell phone is not a text message to anybody. It's in the notes section where she has a list of rules, correct?
Yes.
Does it have a title?
No.
Okay. And the government's position is that this is something that she was told that she made notes about.
That's correct.
Presumably, she would testify to this as well.
Yes, she will.
So with that context, what is your position on it?
Well, given the way the notes are created, it's unknown if she actually created the notes. It's on her phone, obviously.
I guess you could ask her. I mean, if she testified, I made this list, it's being offered to prove that the list was made, not for the truth of the matter exerted. So do I have that right?
Yes.
So I don't see it as hearsay. I mean, obviously, if she didn't write it, then that's the end of the inquiry. But if she says she wrote it and what the reason was, it's really not hearsay. It's evidence of the fact that it was made. So with that understanding, that's admissible. Of course it is. The next thing I feel like you all can agree on this, the question about the dates of various concerts in 1994. Can't you come to some kind of stipulation about that? I know this is a question about the newspaper reporting that concerts took place on particular dates in particular locations. I don't see that as especially controversial. Do you have a problem with that?
Your Honor, there is a list. There's an archive of Mr. Kelly's concert dates, so I think we can go over those with the government and make sure that we're in agreement with what's listed on the archives.
I think that makes sense. See if you can do that, and then you can probably just stipulate rather than put it in these old newspaper articles. But okay, that I think covers what the government was requesting in terms of these other acts.
Your Honor, maybe we have 1 second because there's a ruling by the court that we might want to revisit.
I didn't hear what you said.
May we have 1 second with Mr. Kelly?
Sure, go ahead.
Your Honor, the court made its ruling.
Mr. Canick, I'm just going to ask you so Ms. Becker can hear you. Just make sure microphone is on. Thank you.
Okay, thanks.
So much better. Go ahead.
Thank you.
It's
Bless you.
Panic.
Oh, I'm sorry. Thank you. The court made a ruling earlier as it relates to the jury number. Jane Doe number 18. What we're going to do is ask the court to. The court ruled that it is not going to allow that testimony to be elicited because it might be cumulative. Thank you. It might be cumulative. We're going to ask the court to reserve on that until Mr. Farinelli gets his response into the court and the government on Friday.
Just remind me. I'm sorry, I'm going to look at my notes because I know this will shock you, but I don't have these committed to memory in terms of who's who. Let me just, Jane Doe number 18.
Right.
You want me to reserve. This has to do with the threats on the Facebook and like, correct?
No.
Are you referring to Jane Doe number 19?
Oh, I'm looking at. Sorry. What did I say?
May I?
I'm sorry, which Jane Doe are we speaking about?
19.
19, thank you.
2018. This is the one that I precluded inquiry.
19. Jane Doe 19.
Just so that I make sure I have the right thing. This is the former girlfriend that the allegation is that Mr. Kelly wanted her to decide whose team she was on and something about her family. Beautiful family that she didn't want to be handled.
I don't think that's the one.
That's
I'm sorry.
That's it. The one.
That's the one?
That's one.
That's the one?
That's one.
I'm sorry.
That's one
Okay.
you decided.
Yes. We have to study our notes, Your Honor.
Okay, just let me know about it.
Okay.
Your Honor, could I raise one other thing with respect to the 2002 trial?
Yes.
Jane Doe number 4 testimony is Jane Doe number 5 will testify that she first encountered the defendant when she attended his trial as a quote unquote super fan.
Why don't we do with that evidence what we do in other contexts? You can refer to it as a proceeding.
Okay.
Just so it's sanitized. I think that's the way these things are generally handled. I mean,
okay.
I'm saying there may be something about that proceeding that becomes relevant. But right now, let's just preclude our reference to it as a trial. All right? So the next thing I just want to cover, which should not take quite as long, has to do with the government's motion in limine regarding evidence under Rule 412. And that rule provides that evidence offered to prove that a victim engaged in other sexual behavior or offered to prove a victim's sexual predisposition is not admissible in a proceeding involving alleged sexual misconduct. There are exceptions to that, and they include whether it's offered to prove that someone other than the defendant was the source of forensic evidence or other physical evidence. The second exception has to do with sexual conduct that is offered to prove consent. And the third is a more general exception which is evidence whose exclusion would violate the defendant's constitutional rights. A defendant who wants to offer evidence pursuant to these exceptions must file a motion that specifically describes the evidence and the purpose for which it is offered at least 14 days before trial. And there's also a provision that the victim, or if appropriate, the victim's guardian or representative be notified. It's possible that the defense and the government are in agreement about one aspect of this, which is, I think, the government is intending to offer evidence that the defendant directed the various Jane Doe witnesses to have sex with one another. I mean, I haven't received a motion that specifically describes the evidence that you're intending to elicit, but I don't immediately see other than that category of evidence that I just discussed, how this could possibly be relevant. So I think the representation, and you'll certainly correct me if I'm wrong, is that you don't know what you might ask about it at this time, but that's really not sufficient under the statute. So if there's a specific, as I say, I think during the period of the charged offenses, the government will in fact elicit evidence of sexual encounters with other people and with the defendant, but I don't. What you're suggesting in the letter seems to fall squarely within the prohibition of Rule 412. And if there's something specific that falls under those exceptions, you can surely file a letter by Friday also. But for now, I'm not going to permit that. I also think the government and defense probably agree on this religious belief question. The government doesn't want the evidence to come out, and neither does the defense. So you agree? So that solves that. The
Judge.
Yes.
I'm sorry, Judge. There would be one that would ask if I could reserve for comments, please.
You can. I got something from Mr. Scholar, I think this morning, saying that you objected to it coming in because I think there's, if I'm remembering this correctly, I think the allegation is that this particular witness said something about somebody being a demon, which I can see why the defense would not want that in.
That's correct, Judge.
So if you won't,
there's others, sorry.
That's all right. If you all want to talk about it, then I don't want this to be a 30-page letter. But if you want to talk about it and then include that, you certainly do that. You can certainly do that, okay? Anything else the government has to say on that score? Just show your honor that we have no intention of introducing that evidence. You're not planning to introduce it. Correct. So maybe you don't have to talk about it. It seems not helpful to anybody. So if you change your mind about that, you can let me know. Then there's a motion to preclude introducing sort of general evidence about mental health. You know, a witness's psychological history might be admissible if it goes to credibility. But just because somebody seeks counseling or help for a psychological issue does not make that person incredible. There's nothing in the submission that I have that indicate that any of the witnesses are suffering from some mental disease that renders them unable to remember, or there's no evidence that the people are under the influence of some delusion. I also just think, as a general matter, lots of people seek psychological counseling, and that may also be true of your jurors. And I don't think you can just assume that somebody is not being credible just because they had a time needed some help. So I'm not going to permit any inquire into that. With respect to one of the witnesses, I think it would be decidedly unhelpful to the defense, just as a practical matter, given the nature of that evidence. So unless there's a showing that a witness mental health affects the witness' ability to perceive and recall, that evidence is admissible. The next category of evidence, I don't think you all are too far apart on this one either. This has to do with evidence about the victim's parents and the allegation that they may have participated in the scheme to extort the defendant. I don't understand that any of the parents are testifying. Is that correct?
That's correct.
Why?
So it's So it's certainly appropriate if you know, with a good faith basis to question the witnesses, whether witnesses participated in such a scheme. That's certainly appropriate, but sort of a general question about what their parents did is really not. I mean, there is no direct evidence of it. So I don't know how the witness would know about it. Unless the witness participated in it, then you can certainly cross-examine them about it. But just a general question about what the parents were doing, you know, in a case with allegations like this one, and the parents couldn't consent to the behavior that's alleged, so it really doesn't have any relevance. So that's not going to be admissible, just generally about the parents. But if the allegation, which is what I understand it to be, is that the particular Jane Doe witnesses were part of this plan, you can certainly ask them about that. Like I say, I don't think you're that far apart on this, so I think you've got that right.
Your Honor, I would ask that we be
Judge,
able to flesh out, and because I do think,
I'm sorry, in what form would it take? That's my question. They're not testifying.
well, in terms of offering defense, Your Honor, depending upon the witness testimony, what elicited from the witnesses and what the witness says, it could be very relevant to the defense. And if in fact the defense should have available to them the possibility of calling one or either parent, if in fact there is information that's testified to that goes to the actual defense, I mean, the parents.
I want to stop you. You're not objecting to them calling the parents, are you?
I can't imagine what the parents could testify to that is relevant to Mr. Kelly's defense. So on
Of
principle,
course you
no,
could.
I'm not
Go
objecting,
on,
but
Greg. Sorry.
I need to make an offer as to how it is relevant to the charges.
Well, I think they did make an offer that, and you'll correct me if I'm wrong. The offer is that this is all an orchestration by the Jane Does and their parents to frame Mr. Kelly and to get money out of him. Do I have that about right?
Yes, Judge.
That's what the motion argues, Your Honor. I'm
Um,
sorry. Okay, sorry.
that's what the motion argues, Your Honor.
Well, I mean,
Or that's what the motion, yes, that was.
perhaps you'll get a witness that will come and admit that in court. I don't know. But if there is a witness to be had and can give relevant, I mean, it's like anything else. You'll make an offer of proof. I'm not precluding you from doing that. I am precluding you from, I think it would have to be hearsay evidence. Like I say, I don't think you're that far apart. You'll be able to cross-examine the witnesses on this topic. So with obviously appropriate questions. We just have two left. It's the next one. It's the evidence of prior good conduct. I think part of this is going to be, I'm not 100% sure how this defense would propose this will come in. Obviously, if Mr. Kelly testifies, he can talk about his background and things like that. but to the extent that it is character evidence, it would have to come in, in that general way that character evidence comes in at a trial, which is it doesn't take the form of a particular act. It's just that someone testifying about somebody's reputation in the relevant community for whatever trait it is at issue. Trait is at issue. And it's a little unclear to me what the acts are, what the good conduct is. Is it that he got awards or something in his music career? I don't know if that's a good conduct, but go ahead, it might be.
I can't hear, Judge.
Well, Your Honor, if the allegations is that Mr. Kelly had the witnesses tied up or kidnapped, or whatever the way the witnesses would phrase it, and there were acts that Mr. Kelly did that disapproved that, we would be able to cross-examine the witnesses with respect to that information. I don't know if that would be perceived as a good act, but we would want to be able to cross-examine the witness with respect to them.
Help me through this, because you can certainly cross-examine witnesses about the details of things that they say, but what you couldn't do is say, but isn't true on some of women. But what you couldn't do is say, but isn't true on some other day he didn't tie the person up and kidnap them.
Understood, Judge. Yes.
I think that's frankly ridiculous, but as I don't understand that you're suggesting that.
No, we're not.
Like I say, I don't know what form this would take. Obviously, if Mr. Kelly is going to testify, he can talk about his background. And if you want to call a character witness to testify, as I said in the general way that character witnesses do, subject to that other part of the rule, which permits then the prosecution to cross-examine the character witness about specific acts. I think I'll wait for the proffer on that. I'm not really ruling on it at all. We'll see what happens. You're not going to call a witness to say just generally he's the greatest guy in the world, because that will violate that rule. So I don't understand you to be seeking to do that.
No, Your Honor.
So I think we're all on the same page. The final request is to preclude evidence that a witness worked as an exotic dancer years after knowing the defendant, or that she was in a lawsuit for unpaid wages. You're not really seeking to inquire about this, are you? It's nothing. It's not a bad act. You guys are all lawyers. People can sue people for unpaid wages. And as far as I know, there's nothing indicative about credibility for somebody who is an exotic dancer. So I feel like you're not going to want to do that anyway, are you?
Judge, we're just trying to envision all the ways the testimony could possibly come in. I think we're trying to do is cover every possibility. We don't know that the witnesses will actually testify to, so we just wanted to cover all our bases, Judge.
All right. Well, you cover them and I'm not allowing it. Okay?
Yes, Judge.
All right. So that is that. I've talked to you about the trial schedule.
Your Honor.
Sorry. Go ahead.
One question about the trial schedule. The trial date itself, are we starting at 10?
I can't hear him, Judge.
Mr. Canick wants to know what time we're going to start. Let's say 9:30. That makes sure that everyone is in place. I'm a big believer in using the jurors' time as best as we can. Obviously, if somebody has a conflict or something, or they need to leave early, I'm not that mean, so I will usually permit if somebody is going to be late one day, we can work together. But it's anticipated it's going to be a long trial, And I think we want to be as efficient as we can. So 9:30, and we'll take a lunch break. I usually take a morning break and an afternoon break. And then between 5 and 5:30, we finish. If the witness is on the stand, assuming the court personnel is available and we can finish the witness, sometimes I'll ask you to stay a little later. I try to give everybody a warning about that, okay?
And Your Honor,
Yes, go ahead. I'm sorry.
I guess this is to the government. Will you be giving us like the lineup of the upcoming days so we'll know who is coming? So we don't have to track all the stuff in here?
They will.
Yes, we will.
Then I did get some on the jury instructions. There were a couple of requests by the defense. We can discuss this further if you want, but I'm giving what are the standards instructions. I think the proposals by the defense, there were just two of them, if my memory serves. They are more confusing than they have to be. So I'm going to stick with what we have, but we've got quite a bit of time to think about jury instructions also. Is there anything else anybody wants to raise?
Yes, yes.
Ms. Gaddis?
Yes, Judge. The government filed a motion to allow certain of the Jane Does to testify using.
I forgot about that one. And there is no objection except to Jane Doe number 5. Is that correct?
I'm sorry, what is?
I'll repeat it.
The government asking for judge?
They had requested that the witness be permitted to testify
Using their first names only.
using only their first names. And the objection is only to Jane Doe number 5. And that's based on the fact that apparently some of these witnesses, I'll tell you, I haven't seen any of these. So apparently some of these witnesses have spoken in other forms. I'm not sure that's a reason to force them to testify about these particular things using their full names. So I'm going to permit the government to do that. I know there's a concern that the jury might attribute this to the defendant. I'm going to give the jurors an instruction as it relates to the anonymous jury, which is a standard instruction that judges can give in cases like this. It happens with some regularity in this part. It's not necessarily attributable to the defendant, but there is a very thorough instruction that explains to the jurors the reason for it. And I'll do the same thing with respect to the use of the first names. And obviously, if the parties have a particular language they want to propose, I'll consider that too. So just submit that.
Your Honor, similarly in the government's other acts motion, we also request the numerous of the Jane and John Does testifying using the first names as well. I assume, Your Honor.
I think the same reason.
Yes.
The same reasoning applies. I don't think you object to that. Do you, Mr. Cannon?
No, Your Honor.
I want to note for the court that the government is going through the process of obtaining monitors for each of the jurors so that they will be permitted to view certain evidence and particularly some very sensitive evidence privately, and we won't be showing it on the big screen. Obviously, less of the issue given that there wouldn't be press in here, but given that there will be an overflow room where the public and the media will be permitted, we think it's appropriate. I don't think there's any objection to that form the defense from the defense.
No.
All right. Okay. Anything else that anybody wants to put on the record?
Your Honor, just a couple of things that
Just speak into the microphone if you could.
yes.
Thanks so much.
Thank you. Can the court make provisions for us after the jury has been selected to have someone from our team to go down to the courtroom that the trial will be held, and so we can become familiar with the electronics, because during the cross-examination, we want to make sure that we're not.
We're going to be, I think, and my courtroom deputy will correct me if I'm wrong. We're going to be right across the hall in Judge Chin's courtroom. The configuration is better that way. We'll be doing the jury selection in the ceremonial courtroom down on the second floor. The method that we'll follow, and again, Ms. Green will kind of correct me if I'm wrong, but the method that I plan on following is we're going to be talking to the jurors in groups first. I'll give them general instruction, as I would in any trial, about jury selection and about the process of the trial in general. And then with those jurors that will be questioning them, I'm going to question them individually, each juror individually. So it'll probably take a little longer than our usual method, but that's what we're going to do. And that will begin next Monday.
At 9:30?
Yes. Anything else?
With respect to your honors mass protocols and giving your jury's addresses, can you let us know what you are thinking at this time? Obviously, knowing everything is subject to change.
I think that the guidance, and I'm going to double check it because it's been changing. The guidance is that as long as everybody in the well is vaccinated, that you can be unmasked, that the people, the jurors, were not inquiring as to vaccine status, and the jurors would be masked. Is that correct, Donna?
Yeah.
That's the way right now the protocol is. The protocol is also that obviously the jury is going to be seated in what used to be the gallery, and I believe that most witnesses would be testifying from the jury box. Okay?
Judge, may I?
Judge, may I?
Yes, go ahead.
Sorry, I can't see what's going on in the courtroom. So I apologize. I didn't mean to cut anyone off.
Still you.
Oh,
Okay.
Judge, I believe also, since I'm not there, I can't sort of lean over. I believe Mr. Koenig wanted to address the transcript for the court as well. The transcripts for the jury trial.
You want daily copy?
Yes. I have a couple of other points that Miss Becker, she beat me to it. Your Honor, Mr. Kelly has not been employed in over the last 2 years. Mr. Kelly has not been employed over the last 2 years. He's been incarcerated. His funds have been depleted. I'd like to ask the court to consider giving him daily copies.
I'll do that.
Thank you. And lastly, Your Honor, we want to make sure that he has sufficient clothing for the trial, and he's gained weight since he's been incarcerated. We're trying to get his measurements. We asked last night, how can we find out? Get someone to take his size. We're told that we either ask you or ask legal.
Well, I'm not taking his size. What are you talking?
Well, we would hope that the court would be able to direct someone to us.
Oh, you want me to direct somebody?
Yes.
I don't know. Do you have a suggestion?
I'm sure we can work something out with MDC Legal.
Okay.
I don't think you need to involve me in this process.
I would hope not.
If you need an order or something, anything else?
Not from the government, Your Honor.
Nothing from me, Your Honor.
All right. Everybody, thank you so much.
Thank you, Judge.
In terms of the questionnaires, we should have that in before the end of business tomorrow or before the end of the day tomorrow. Tomorrow?
What you mean? Midnight? No, midnight would not be helpful. Can you get it in by 5 o'clock?
I would be in the jail. I would be at the jail, and I think that Mr. Farinella is going to confer with the government once we get all our information. So hopefully, maybe 6, 7.
Hold on one second. Let me just check.
The questionnaires.
It really should be the end of business. And also, folks, just recall that if we can get a group of people on whom you all agree, and that's happened in these high-profile trials before, that the parties have been able not to agree on the ultimate people who would be on the jury, but to agree on the people who can be in the pool.
Yes.
So that's especially helpful. All right. Thank you so much.
Thank you.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Judge.
All right, guys. All right. Did anybody have anything to say?
I'm kind of curious though. Okay, she ruled it as now. Azrael didn't witness anything regarding Aaliyah.
That wasn't Azrael. That was Javante.
No. I'm talking about when she said. Remember, she said R. Kelly told her that he something about him and Aaliyah.
Oh yeah.
And they said, well, we're gonna admit that because that's direct evidence. The defendant told her. But then when she talks about her parents being part of a scheme, they saying it's not direct evidence unless the parents. That's contradictory to me.
Mm-hmm. It was. It sure was.
That's why I was like, wait a minute, you're gonna allow her to say, even though she wasn't even born she wasn't even thought of, I don't guess, when Aaliyah was here. But you're gonna allow her to say, well, the defendant told me. That's hearsay. If he didn't confirm it. But then when she gets on the stand and says, her parents, this is a part of her parents' scheme, and her mama was texting him and blah blah blah. But you're gonna rule that that's not direct evidence. That's not right.
And the fact that they couldn't even come in and testify.
Exactly, because they knew. They knew he was going to get tore up on that.
Exactly. The prosecution made sure they played their cards right as far as.
Oh yeah, they were smart. They were smart. Mm-hmm. It was real smart.
Yeah. But yeah, I just didn't like the fact that they would dig anything before 2008 should not been admitted, it should not have been admitted, it should not have been talked about, it should not even been referred to. And the fact that y'all would go into 94 and 96 and all that lets me know that you really wanted a do-over for those prosecutions that lost that case or that he was acquitted on. Because anything that before then that you went after him on and got admitted into this trial right here was just downright wrong. Downright wrong.
Because the state, like his trial, why didn't y'all go after why didn't y'all file charges for Geronda after the trial? Since you saying he tampered with the jury and all that stuff, why didn't the state come up with some more charges? Then instead of waiting 20-some years to, after the Fed hand down some charges, y'all gonna come up with some more charges. It's just wrong all the way around. It just don't make sense to me. It doesn't.
Yeah.
It is crazy. It is crazy, crazy to me.
That's what Cheeks said. 1994. You're telling me they bought up that year in 2021?
Yeah.
Yeah, exactly.
Yeah.
Exactly. Let you know they didn't even have a case against this man. Because when you start talking about something in 2016, 2017, and 2018, right there, you didn't have enough to do nothing with. So you had to go
Exactly.
all the way back to 94 or whatever to bring that in and bring these
Mm-hmm.
people in or bring these Jane Does and all this stuff in. And even actually had a John Doe. Because I never heard in my life, out of all this time that
Exactly.
I've been knowing R. Kelly, that he was messing with a guy. I mean, a young boy and stuff.
Exactly.
Never ever
Exactly.
heard that.
Never.
Well,
That's
he's
why I
Never.
supposed
say that the prosecution can juice up their case and bring in any lies or anything like that as long as they can get somebody to say, yeah, he did it.
But you know
Mm-hmm.
what get me,
Exactly.
y'all? How did Larry know all of this? Because he remember
Yeah.
he said two guys. How did
but
he
you know,
know?
Yeah.
is he didn't even want the girls looking at guys, but yet he wanted to watch them have sex. Come on.
Mm,
What-
yeah.
Yeah.
Well, yeah,
Something's
this is
fishy.
yeah, this was yeah. You can see just from the start of how Robert was railroaded, like
Mm-hmm.
Bill Cosby said, he was railroaded from
He
the
was
beginning
railroaded.
from
Yes,
all
he
this
was.
stuff right here and what you
Mm-hmm.
wouldn't allow in and what you were allowing in, and then talking about, oh well, you know what, I won't make a ruling at this time. We'll just have to come back to it and stuff.
Mm-hmm. And I guess she got amnesia because when she ruled that Azrael's testimony was so inconsistent, she got trapped in all that. I need to make a ruling. I'm gonna rule on
Yeah.
impeachment, and I guess that just went out the window. She forgot all about that.
Yeah.
She got
Yeah.
amnesia real quick on that.
Yeah. Yeah. Very interesting, wasn't it?
Hmm. It really
Hmm.
is.
Hmm.
It
Yeah.
really is.
Yeah. Well, I know it's getting late for a lot of y'all right there. You know, we can have open discussions. Sylvia, how you want to do that there? Because it is my
Co-host,
bedtime.
you're supposed to be saying something.
I'm supposed to be saying stuff. Ooh, okay, check your email right real fast. I just sent you something too. But yeah, this is you know, according to what we read and everything that um it looks really good as far as an appeal for Robert. And it wasn't just some of these were the mistakes at the beginning and what they were allowing and was not allowing in. So just on that part, the motions for that right there alone is really good for him. And
Let
also
me ask you
during the trial.
something.
Hmm.
So, which judge will be handling the appeal, though? Is it going to be her?
I think it is. Well, no, I think
Oh,
No,
it
oh,
goes to the
no.
appeal court. No, it would go to an
The appellate court.
appellate court. Yeah, no, not her. It would go to an appellate
okay.
court. Yeah,
Okay.
no,
'Cause I
because
was going to
that would
say, if
be
it's her,
conflict.
oh
That
my
would be
God.
conflict of interest and stuff. So she couldn't
No,
do
but
that.
they're gonna first see if she don't they have to go see if she admits the mistakes, and if she doesn't, that's when they have to go to the appellate.
Yeah, I believe
She's going
so.
to make more mistakes.
Oh well, if she sit there and read this whole thing like we doing over and actually see what the jury, where she should sit there and just actually rule in favor of him having an appeal uh, um, granted just by what the jury didn't do. And it
Right.
still sticks with me and will always stick with me that they did not deliberate
They
for
didn't,
what,
they didn't,
9 hours,
they
I think
didn't,
you said 9 hours,
yeah,
and you
9
had all
hours.
that evidence.
yeah.
So you didn't look
They
at
didn't do
nothing.
that.
You
They
didn't look
went
at nothing.
home and that was it. Came back
But
and yeah, he
the other
guilty.
thing too, I have a problem with. Why wasn't his character witnesses allowed? That I don't
Yeah.
understand. I've never seen a case where character witness is not allowed.
Hmm. That is true.
They didn't want him to be looked at as being anything good other than the character that they portrayed him to be. And that was the monster. That's all they wanted him to be portrayed as. which is
And that was
crazy.
the part that got me when the judge was asking Canick, well, you could bring that up to the jury and let them
If
know
he
when it comes to,
testified,
yeah, when we give them instructions, you can, like the jury wasn't paying no attention, wasn't going to listen to nothing because they didn't even listen to
no.
anything anyway. So that was a waste of time saying that.
Yep, that sure was. And she knew it. She knew it.
Yeah. Yeah, they did. They did do that. Elizabeth, they plastered themselves all over social media platforms. Yes, they did. They did. Yeah,
And
so
everybody's having a good time.
well, they
Yeah,
can for
everybody's
right
happy.
now. They can bask
Everybody's
in
happy,
whatever they
yeah.
think they need to. You know.
Yeah, they happy.
Yeah,
They
they can do
laughing
that
and
right now. It's
making
all
their
good.
jokes and all that stuff. Yeah, they making their jokes and all that stuff. So
66. Okay, yeah. So right now, yeah, like we always said that, you may have won a victory, but the war, yeah, it still remains to be seen. So, um, and again, you see, it's all faded out now. Until now, when is his court date, Sylvia? That you said when is Robert's court date?
October 20th.
October 20th. So we got what is that? 15, 16 more days
Yeah,
before
that's
that
for the
starts.
Illinois.
Now, have they moved him back to
No,
Illinois
they're
yet?
not gonna. He's gonna do a teleconference. He's gonna stay in New York.
He's
so since
wait.
he was found guilty in New York, that's where he's. If just say if they drop all the charges in Chicago, he'll of course be remaining in New York.
Into New York until
Until to
sentencing.
the sentencing.
Well, no, if they drop it in Chicago, there's still another one, I believe, in Minnesota, right?
Yeah,
Minnesota's
but he's
not
probably
there
gonna
yet.
keep him in New York. Yeah.
Yeah.
Okay, so after Chicago, just to say they go all the way through with Chicago trials, and let's just say same thing happens in Chicago. Let's just say. So will he have to, whatever, when they sentence him in May for New York, will he have to stay in New York until that sentence is done before they transfer him to Chicago?
He has to go to trial. He has to go to trial in Chicago.
Right.
Yeah, so the question we're asking is, does he remain in New York until his trials start in Chicago?
Yep.
And when his trial starts in Chicago, that is when they will bring him back to Chicago, and he will remain there until his trial is over.
Yeah, but see, the thing is, he's gonna stay closer to where his family or home is. Remember, that's the ruling. They'll put you someplace close to where your family or your wherever is close to your dwelling.
Well, I'm saying that, which is in Chicago, right?
Yeah, it's gonna be someplace
Okay.
close in
Well,
Chicago.
I mean Illinois. What I mean, not I'm just saying Illinois. So doing it. So then here's another question. I mean, here's another, question. His trial starts in Chicago, and he is found not guilty on all those charges there. Then he will be returned back to New York, correct, for sentencing.
He has to go for sentencing, yeah, for New York.
Yeah, no, I'm saying once the trial is over in Chicago and he's found not guilty, because I'm going to put that out there in the air, and he's found not guilty there, then he will have to be returned back to New York because that's where he was found guilty at, and he still has to wait on sentencing, which is May 2022.
Yeah, May 4th, 2022.
Okay. And if once he's found not guilty in Chicago with that trial right there, then there is no way that they're going to work out any type of bail for him because he has been convicted. Well, he has been convicted.
I don't know about that part.
Well, I'm saying because if he was convicted, well, no, because he should be able to have bail because especially if they're able to appeal it before, but I think like the lawyer said, and I think I said it too, that they can't appeal until she has sentenced. Right.
See, but what
right.
they could do is go to the appellate on the to set aside the verdict or something like that.
Oh yeah, have the verdict set aside.
Yeah,
while
something like
they're
that.
while it's been, and at that point, it's possible that if he if they raise enough money and stuff right there, that he can be bailed out. I mean, that he can receive bail. Hmm. So we're gonna put that in the air that he's gonna be not guilty, because that's gonna be interesting. He's found not guilty, and now in Illinois, because this is federal there as well, right?
And there's a state too.
Yeah, the state is, oh, state in Illinois is state and federal.
Mm-hmm.
Oh,
Yep.
they're really trying to just do this man in.
Hmm.
So the
Yep.
question
And here's
is,
the key. There's a key. Geronda's in all three different cases.
I was getting ready to ask that. Will they be using the same witnesses? The prosecution, will they be using the same witnesses in those trials as they did in this one?
I know Geronda's the same one.
Because
The
there's
others, I don't
several
know.
of them that live there in Illinois, correct? Several of the
I
Jane
guess, I
Does.
guess those uncharged ones were probably gonna be same witnesses, because some of those things sounds alike.
Yeah, but if they didn't live there in Illinois, I don't think they could be or should be called as witnesses, especially if there's a state and federal charges of that state right there. So, but yeah, that would be interesting to.
I mean, they're not all the same charges, though, are they?
I don't.
Well,
Have they even given the charges?
Geronda's in all three cases.
Yeah, she's in all three cases, but are
But
they
it's not
charging him with the
no
Mann
Mann
Act
Act or none
and
of that stuff.
racketeering? Are they? That's
Right.
what
So
we're
they got
asking.
different titles for their charges. That's what I guess that's what we're trying to.
Yeah, he's not being charged with the Mann Act, and
Coercion, and all that. That's the same thing. That's what he's being charged for Geronda.
no, but we're saying like they
It's
had the
not
Mann
called the
Act
Mann Act or
It's
RICO.
no
and
Man Act,
racketeering
but
and RICO.
Right.
it's the other stuff. Remember the underlying act. There had some coercion and sexual under with the minor. Remember all that?
Hmm. Right, but what I'm saying is there's no RICO here in
No, there's no
Illinois.
RICO and
Yeah, okay, so
no.
there's
Well, it
no
ain't no double.
RICO
It wouldn't be no
and
double
there's no
jeopardy or
Mann Act,
anything.
which
Yeah.
he should be able to win those right there with this, because it's not, because this is the only way that the prosecution could could try to secure this win, was to charge
Mhm.
him with those old
But
charges
here's the
of.
deal, Geronda, that it would be considered double jeopardy, because if it's coercion of a minor and all this kind of stuff, it's the same charge, but it's just
Hmm.
federal.
But they got it. I mean, the way they have it charged, it wouldn't be.
Yes, it is. Go read it. It says coercion of a minor. It's an act.
Right. But see, but all those acts in the New York case fell under the RICO, and he's not being charged with RICO. So they
Yeah,
got
but there were acts that was done in the state of Illinois. There were crimes supposedly done in Illinois, and it was the same crime. It wasn't new crime. I'm going by what the lawyer said, that they would be able to do a double jeopardy on hers, because he's already been convicted of that.
Hmm.
I was just trying. I mean,
I believe that he will, because there are no charges like this right here, and they had to reach the fact that they had to reach all the way, and that's why I said that I think that because Canick got it late, and I don't know what the previous attorneys now were doing based on that right
Nothing.
there.
Nothing. 'Cause
Exactly. I think that's why they
missed
were
filings
replaced.
and all that kind of stuff. Nothing.
Yeah. So I
oh,
think that's why they
Sylvia,
were replaced,
Mhm.
did
because
you see Greenberg's tweet today?
No, what he said today.
Honey, he I guess it was in reference to, was it Farinello? He said, now I gotta go in and clean up your mess.
That was
Y'all
oh,
mess.
it does some.
That was
Yeah,
yesterday.
or whatever, yeah.
Or isn't that song just even speak and say
Mm,
something like that, period?
exactly.
The fact is that you shouldn't have never allowed them to bring anything before
Exactly.
2008 into this case and have it
Exactly.
there. You could have ruled,
So
you could have, if you would have sit there
the
and
mess
did
you
your
gotta
homework.
clean up is what you left.
Right. You know, you shouldn't have. You shouldn't have never. They shouldn't have never had that, because to me,
Exactly.
what you did is you gave the prosecution a do-over
Hey,
for
yep,
Chicago and them
yep,
not not winning that case. So what we're going to
exactly.
do is we're going to pick out the lady in '94, and we're going to pick out another one in '96. So I couldn't believe it when I was reading that. You know, it's like,
Hmm.
wait a minute, '94, '96, and I had to sit there and go back and look and say, well, wait, he was acquitted in 2008, and obviously y'all going back to females that
Should have
were
been with the one in 2008.
exactly,
Exactly.
exactly. My point
Exactly.
exactly.
Hmm.
Or it should not have been admitted, period. It
Right.
should not have been admitted, period.
It's the statute should have fell on all those. If the state didn't charge them or the federal didn't charge them 20 years ago, those shouldn't even been brought in.
Well, think of this right here. Had there not been a television series
Mm-hmm.
of what is that, Surviving R. Kelly, R. Kelly will
Mm-hmm.
still be a free man today.
That is
Had
true.
there not been a series, so obviously someone behind the scenes, besides the producers and them, were actually conspiring to take this man down. And the only way you could do it was to bring up a false lying series of these things that these women said happened to them. And then you notice that when that series was over with, that female, whoever she was, the district attorney was from Chicago. I guess they were getting enough feedback or some, you know, the opinions of people and how they
Mm-hmm.
felt and what they thought and all this other mess right here. And then she came forth with a press conference, I do believe, saying that if there had been anyone or these women or anyone that had felt that they were sexually assaulted or anything by R. Kelly, our office doors are open. You can
Yep.
come and talk to me. And the fact that it was 3 weeks later and she still didn't come, nobody came forth right there, was telling me that they didn't have anything. But it wasn't
Mm-hmm.
until this lying, uh, um, um, what is his attorney, who's serving time right now, like R. Kelly, saying that he received the tape. See, he was a media, I ain't gonna call him a media whore because that's what he was right there when he was trying to represent uh, Stormy Daniels.
Mm-hmm.
That fool right there came forth and he had a press conference holding up a tape saying that he was given a tape right here of R. Kelly and it was a VHS. I say, wait a minute, they don't even have VHS tapes anymore.
Exactly.
They don't have VHS players. So you come up here with a propped VHS tape and said this tape here has this is evidence that he's received from someone, and he would not name them, that he has right here where it shows that R. Kelly is performing acts on a minor and stuff was a lie because it was all to build and constantly add on to the lies and stuff that these females told and that he came out there with. So they conspired against this man to sit up here and
Yeah,
do
they
this to
did.
him and do
They
this
did.
right here. I don't care what you say, that's what they did. And that's how it played
Mm-hmm.
out. And he is no more uh 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 what his name? I'm trying to think of, I can't think out. I'm having a brain right now as the name of that attorney right there. But his behind was sitting up there, huh?
Abenati.
Yes,
Yeah.
thank you. Get Avenatti. Yes, was sitting up there and trying to extort Nike and all. That's all he did. He didn't even. He took the money from his
Client. Own client.
clients, their settlements and stuff. And oh my goodness, right here. And you mean to tell me that this man here, that you use this information right here to come against this man. And so now what? It attracts the federal agents. It
Mm.
attracts federal agents that are sitting in rooms with their notes, taking notes that Kanik had proved. You're taking notes where they're in the room for 4, 5, 6 hours. So you were plotting this out. You had the script written. You had to have her in there to read over what it is that we're going to ask you, what it is that we're going to, and all of this information right here was made up for him to eventually do exactly, because they already know that they had these witnesses in place. How do
Yeah,
we
they
even
did.
know? But they
Uh,
had
Mhm.
it in place. They had them in place.
Yeah,
And
they
they
did.
gave it away by their short deliberations that they had right here with all those exhibits that they never read and never went through. So it wouldn't have mattered what Kanik would have
It
stipulated to
sure wouldn't
them
have.
during the
They already
jury's
made up
reading. It wouldn't have mattered because their minds were made up, period.
already. Mm-hmm.
Period.
So they wouldn't have married.
Yes. hmm
So
So,
they knew they was gonna win anyway. So
yeah, for
they had
real.
everything in place. And I believe what Spitting Fire said, some of them, she believed those jurors were the Me Too people.
I wouldn't be surprised. You know
I
they're
wouldn't
gonna
either. That's
lie
why they
just to
wanted
be
them
on that
anonymous.
case. Yeah, they're gonna
Mm-hmm.
lie to be on that case when they're sitting there acting as though they never heard. Have you ever heard anything about R. Kelly? No, no. Who is that? Who is R.
No.
Kelly? You know, and
Yeah.
all this right here to be on this jury. I don't know R. Kelly. I don't know. No, what is this right here? Well, he's the only next biggest person after Michael Jackson, basically, and stuff.
Exactly.
Loved worldwide. So I don't see how you cannot know or have anything. I mean, know anything about him or have an
Exactly.
opinion about him. If you even had one about him in 2008 and 2009, right there, you sure wasn't going to tell him that you had an opinion about him and what you felt
Exactly.
about him right there and did that right there. So come on now. Come on now. Your actions showed it when you deliberated only for 6, 9 hours right there. Right there.
Exactly.
So
So they
you
didn't
didn't
they didn't
do.
look at nothing.
So hopefully, like I said, just hopefully that verdict is set aside, especially why they investigate and look at what it is that did and didn't happen regarding R. Kelly and stuff. So yeah, so we want to thank everybody in the chat room. I'm just going my part right here. I want to thank everybody. There's 126 people still in here. We have
Oh, boy.
156 likes. Thank you so much. 13, 13 others and stuff right there. And appreciate all my panel reading. I enjoyed you so much. Always enjoy you right there. And Sylvia, she
yeah.
got her hair whipped up. She was looking like Spiky earlier and stuff, according to some of the according to some of the people, huh?
I'm laughing at you.
Yeah, no, I'm just saying I was reading it. I never called you Spiky. They was just saying, up there doing the spike thing or something like that. I don't know. I was reading some of the comments and stuff like this, so they was kind of funny. But she pulled through right there. Even though I liked it, I didn't see it. Now, who was that? Somebody said that you looked like one of them characters from what was that? Rugrats or something, right?
I
Oh
look like
my Lord.
I thought that was funny right there, and stuff right there looking. But yeah, I appreciate you all stand up late with us because I do believe that 8:49, 9, 10, 11:49. So it's almost 12 o'clock. For those that are 3 hours, that's for you too, Sylvia, right? It's
Yep,
almost
that's why I'm about to
midnight
go
for
to
you and
bed.
stuff.
I know that's right. It's
So
almost 11. I gotta get ready for work
yeah, it's
tomorrow. So.
almost 9 here, and it's past my bedtime and stuff because I will
Oh
be up
wow.
going to
So good
work on the
night, good
3 days.
people. Good night, good
All
night, good
righty.
people.
We'll chat
Appreciate
tomorrow.
appreciate all of you in the chat. Y'all have a beautiful night
You
and
too.
stay safe.
You
And
too.
we'll be ready for the next time that we come on.
All
All
right.
right.
We'll
All
Good
chat.
right
night,
then.
everybody.
Good
Good
night
night.
there. Good
Good
night,
night.
Chat.
Love
Good
y'all.
night, John Paul. Good night, Mary Jane. Good night,
Good
Billy
night,
Bob.
Sue Ellen.
Bye. Good night.
Good night,
Good
John
night,
Boy.
Sylvia. Good night,
Hey,
Henny.
you telling your age now. You're telling your age.
Good night, Kenny.
Good
Good
night.
night, dear. Good
All
night,
right.
Judge.
Bye.
All right.
Bye.
Good
Bye.